Thank you all for coming. My name is Tom Leonard. I'm president of TPI. Thank you all for coming to this session on patent reform in the 114th Congress, disentangling the evidence. Obviously, patent reform is very high on Congress's agenda right here, and proponents of reform argue that the current system produces excessive and even in some cases abusive litigation, particularly on the part of patent assertion entities, or less charitably referred to as patent trolls, and that this imposes costs on entrepreneurs and others, and ultimately has the effect of deterring innovation. On the other side, the argument is that the litigation, the so-called litigation explosion is overstated, and that patent reform is going to weaken intellectual property protections to the detriment of innovation. And complicating, of course, this issue is the fact that the effects of the America Invents Act, a number of recent court decisions, as well as changes at USPTO are still unfolding. And in addition, the FTC has underway a 6B study on patent assertion identities that hopefully will provide some new data and new understanding of the issue. So reflecting this debate, we essentially have competing approaches in the Congress. Representative Goodlatte has reintroduced his bill, the Innovation Act, which is aimed at curbing abusive litigation. And House Republicans reportedly are hoping to bring the bill to the floor very soon, perhaps later this month. And on the other side of Capitol Hill, Senator Coons has introduced the Strong Patents Act, which patent holders tend to favor. So the question for Congress is how to curb abusive litigation without weakening legitimate IP protections. So what we have here today is what we hope is going to be a very informative program that's going to try to disentangle some of the evidence and some of the arguments. And we have a very distinguished panel. We're going to go down the panel in alphabetical order. Each of the panelists is going to give brief opening remarks of 6 to 8 minutes, and then hopefully we'll have an interchange among the panelists, and then we will open it up to you all. So I think we have enough time to have a pretty good discussion. Our first panelist is Eli Durado. He is a research fellow at the Mercatus Center at George Mason University and director of its technology policy program, where he specializes in internet governance, intellectual property, cryptocurrency, internet security, and the economics of technology. Eli?
Thanks, Tom. I'm very grateful to be here and to be on this distinguished panelist, with these distinguished panelists. So the most basic question posed to us, I think the title of this event is, what does the evidence show? What does the evidence show about patents? And I think the most basic answer comes from a couple of economists, Boldrin and Levine, in the Journal of Economic Perspectives, which is one of the top economics journals. And they write that there is no empirical evidence that patents serve to increase innovation and productivity. I'll say that again. There is no empirical evidence that patents serve to increase innovation and productivity. And they also write, in spite of the enormous increase in the number of patents and in the strength of their legal protection, the US economy has seen neither a dramatic acceleration in the rate of technological progress, nor a major increase in the levels of research and development expenditure. And I would note that if anything, we're in the middle of what my colleague Tyler Cowen has called a great stagnation. So I think that's really the bottom line, or the baseline from which we need to be talking about this issue. The empirical evidence suggests that the patent system as a whole does not accomplish much, or maybe is a net negative. So it's worth thinking about this. How can this be? We have a government program designed to promote the progress of science and useful arts, and if anything, it's doing the opposite. Now, does that mean that patents are bad? Actually, Boldrin and Levine think so. They would get rid of patents entirely. My view is much more moderate. I think that there are parts of, the way to square this evidence is that there are parts of the patent system that go too far in protecting ideas. And those parts fully cancel out the benefits of the parts that are appropriate. So the best policy solution, in my view, is therefore to remove the parts of the system that have negative effects so that we can maximize the total positive effects of the system. I think there are two interrelated sets of reforms that I want to raise, and one is what Congress has already begun to address with the Innovation Act, which is patent trolling. And then the other is broader questions of patent quality, which Congress has not really done very much to address. So I'll just say a few words on each of these topics in my remaining time. So one of the most unfortunate aspects of the patent troll debate is how I think trolls have been defined by both sides. It's always discussed in terms of non-practicing entities. Now, to me, there's nothing wrong with being a non-practicing entity or even a non-inventing entity in general. I think it's good that we have a secondary market for patents, and it's fine that these secondary parties are able to claim damages and receive judgments for patent infringement. The problem is not non-practicing entities. The problem is the asymmetries in the legal system that these parties exploit. So troll should be thought of as a verb, not as a noun. So let's just go through a few of the asymmetries in the legal system. Let's say I own a bunch of patents relating to Wi-Fi. I send letters from a shell corporation to coffee shops saying, I have reason to believe you're violating some of my patents, but I won't tell you which ones. Pay me $2,500 or I will sue you. Going to court will cost you more than $2,500, so the rational thing to do is to settle. Let's say the coffee shop doesn't settle. They can go to trial, and the first step of trial is discovery, which can cost 6 or 7 figures for an operating company, and it costs $0 for the non-practicing entity because they're non-practicing, so they don't have any documents to produce. So after discovery, you might be able to get the case dismissed, but in that case, you're still out 6 or 7 figures, and the plaintiff is out 0. Let's say the case doesn't get dismissed. Maybe you win, maybe you lose. Either way, even if you win, you're still out 6 or 7 figures, more than the plaintiff is. If you lose, you're obviously out more, because then you have to pay damages on top of that. So once you get sued by a non-practicing entity committed to exploiting asymmetries in the legal system, there's no way to win even if you did nothing wrong. And by the way, this Wi-Fi shakedown actually did occur in 2011 when Innovatio IP Ventures LLC sent demand letters to hotels and coffee shops who offered Wi-Fi to customers, even though some of those shops had actually routers that they had licenses to the relevant patents. They paid anyway until Cisco stepped in to defend many of their customers. So that leads to a second asymmetry, or a variant of that first one. It's if you make Wi-Fi routers, I'm going to sue all of your customers unless you pay me. So companies will do almost anything to prevent their customers from being sued, so the incentive is to settle rapidly. A third asymmetry. You have patents that make up an engineering standard, and you've licensed your portfolio to the standard setting organization on fair, reasonable, and non-discriminatory terms. So your strategy then is to transfer the patents to a non-practicing entity, so it is no longer part of the pool and subject to FRAND, retain a license for yourself, and make a condition of the transfer an obligation to maximize the licensing revenue of the patent. So the result is that you get a mysterious shell corporation going around suing your competitors. So it's great. So the plaintiff knows who the defendants are, but the defendants don't know who the real party at interest is on the other side. So that's another asymmetry. And so my view is that the Innovation Act, what it does is actually very modest and appropriately tailored to dealing with these issues. It doesn't go after non-practicing entities or the idea of a secondary market in patents. It goes after the asymmetries in the legal system. So you create a loser pays rule for patent litigation, which reduces the incentive to settle in frivolous cases. You make the plaintiff specify which patent has been violated and how. You move the phase of the trial in which the court decides what the patent means, the claim construction hearing, to an earlier in the process. And that means that in cases where the patent is invalid, not all of the discovery costs will have to be borne. You make the plaintiff disclose who really is its parent company. And you stay customer suits when a manufacturer steps up to challenge the litigation. So in my view, none of this unduly burdens inventors who have legitimate claims of infringement. Inventors should be willing to stand up and say, this is my name, this is the patent you violated, here's how you violated it. Let's have the court decide right away what the patent means. And I'm so sure that the case isn't frivolous that I'm willing to accept the risk that I'll have to pay your court costs if I lose. So what's so bad about that? I don't think, I think that's totally reasonable. So I want to just say, moving on to the other problem, the bigger problem, or an additional problem that goes beyond trolling, is the root problem of patents. There's just way too many patents. We've just granted way too many patents. We're granting now up 325,000 patents a year, and in 1980 it was around 70,000. So, I mean, if you think about that increase, I mean, we're talking about quintupling or nearly quintupling the rate of patent growth. And I think that there's just incentives at the USPTO to grant, be too permissive, because the USPTO gets revenue from fees for granting patents and for maintenance fees. And I think too many patents are being granted that are not that are obvious or not novel. So, for example, patent shipment notification, or retrieving information from a database, or making reservations over the internet. And so, I think I will run out of time, but this is all bound up in especially software patents, and especially the jurisprudence of the Federal Circuit Court of Appeals on what can be patented and sort of the subject matter limitations. So I'll just end there so that I don't keep going forever.
Thank you. You'll have other chances. Our next speaker is John Duffy, who is the Samuel H. McCoy, the second professor of law at the University of Virginia Law School. Previously, he taught at the George Washington University Law School. He's one of the most distinguished scholars of intellectual property. He's been identified as one of the most 25 most influential people in the nation by American Lawyer, and one of the 50 most influential in the world by the UK publication Managing Intellectual Property. He clerked for Judge Stephen Williams at the U.S. Court of Appeals, and for Justice Scalia at the Supreme Court, and has a number of other distinguished things on his resume. John?
Yes.
Yeah.
Okay, fine. So I want to go back to an earlier period when Congress thought for sure that they had a reform that was desperately needed in the country. And that was at a time in 1847 when they thought the one thing that should never be granted, and there was a major lobbying organization that had just been born that was sure that there should never be a patent granted on a medicine, ever. Because the American Medical Association said that for a physician to hold a patent for any surgical instrument or medicine was reprehensible for the physician. It was reprehensible even to attest to the efficacy of that or to prescribe it in any way. And that's why the one field out of all the patent system that we wanted to abolish then was not patents on machines, it was patents on medicines. And the one area today, merely 150 or so years since, the one area where economists generally agree, and I see nodding here, is the one area that we have really mountains of evidence to support the patent system now. It is on medicines, medical devices, and other areas like that. So my first message is the absence of evidence is not a good argument. In the 1840s, you did not have good empirical evidence, or in 1790, there was not good empirical evidence of the efficacy of the patent system. Note also, there was no good empirical evidence of that an abolition of a patent system would be a good idea. In part, it was based on theory, a theory that property rights encourage people to invest and provide economic incentives for them to innovate. Now that, we can talk about the details of more modern studies, but we have to recognize that through our history, the patent system has enjoyed some considerable success, even despite skeptics like the American Medical Association, which I think it's true that doctors now do prescribe patented medicines, actually with some degree of regularity. And not only do they prescribe patented medicines, they prescribe, and this is the true benefit, they prescribe patent medicines that were patented. Those are the medicines that we get at marginal cost now and at a relatively low price. Because the costs of innovation, the costs of research have already been paid for society, and the next generation of medicines can build on the top of that innovation that has already occurred. So it's just important to remember that just because we don't have evidence today doesn't mean that we should not continue the patent system. We've had a number of successes throughout our history. People like Edison and the Wright brothers, the inventors of the lasers, and other major inventors who clearly were motivated by the patent system, clearly did think that the reason that they were going out and expending money was the promise, the hope that they would be able to enjoy some degree of patent rewards if they were successful. So I think that we have historical evidence that's pretty strong that people did look to the patent system and build businesses and research labs around the patent system. A second point I'd like to make is why there's so much discussion of patents today. And I want to make the point that it is actually a success story of our country, a success story of deregulation. Why were there no cell phone wars in the 20th century? Cell phone technology began to be understood in the late 40s and early 50s, that you could actually do something like this. Well, you didn't need patents then, of course, because there were major research labs like Bell Labs. It had a monopoly guaranteed by the government. I actually worked at Bell Labs when it was just leaving its monopoly status. And no one there really worried about patents too much, because after all, what could patents give you? They could give you an exclusive right to practice your new telephone technology in the United States. Well, they already had an exclusive right by and large, and they were trying to transition to this new, much more vibrant era where there'd be a lot more competition. And that's why we have cell phone wars. The cell phone wars are a form of competition. They are competition, long-term competition over innovation. And that's something that we lacked in the 20th century in that one industry. Instead, we had a monopolistic, regulated industry that had a completely different model of innovation. I think the model of innovation is significant. One of the topics that Tom asked us to discuss was the recent legislation, the AIA, which changed the patent system in some ways that I think might be good. We, for example, harmonized our system with the rest of the world so that we have something like a first-to-file system, which has various advantages, including that we're more consistent with the rest of the world. There is one aspect of the AIA that I think is troubling and should be troubling to the Congress. The AIA has authorized a vast expansion in the bureaucracy, and that is not something that you necessarily think should be uncontroversial in Washington. Maybe it oftentimes is too uncontroversial, that we'll have a vast expansion of the bureaucracy and that will be the way to solve the country's ills. I'm a skeptic of that. We've had a lot more, the Patent Office is hiring, it's building, it's expanding, it's building offices in other parts of the country. I'm not so sure that that's the way to solve our system. As prior speaker just mentioned, the patent system is run on a fee system. If they're expanding, they're going to have to try to develop fees from both parties in the industry, either patentees or the people who are accused of infringing those those patents, and that may not be a good thing. Related to that is the expansion of the number of patents. I think that that is a serious issue, but I think it's a slightly different issue. There are some problems with obviousness. About 8 years ago, I was involved in the litigation known as KSR, and actually thought that the standard of obviousness needed to be tightened up, and was successful in getting the standard changed somewhat. I think there could be still some reform on that, and if Congress wanted to do some legislation on the substance of patent law, I think that might be a very interesting way to go down. The current bills, so far as I know, have no substance in front of them. They're instead a variety of procedural reforms that are attempts to change things. A lot of the reason for the expansion of the number of patents is because patentees cannot rely on just a few claims anymore to cover their technology. They need dozens of patents because claims can be interpreted in any number of ways, and they have to try to get as many possible variations of verbal formulations to cover their technology as possible, and obviously that is in the patent office interest because that generates more fees and more fees to run the large bureaucracy. I will say one kind thing about the legislation that's before the Congress. There is, among other things that the Patent Office has done, which I think is not defensible, is a fairly technical rule, which is something called the broadest reasonable interpretation, which says that when a patent is challenged as being invalid inside the administrative agency, the agency, even if the patent has been issued for years, will usually, not as it turns out always, but usually construe the claims in a different way, in a way that's less favorable to the patentee, a way that's different than the courts. And I think this is this is the one part of the legislation that I think is something that should be enacted. I will say that it should give Congress pause that the administration, the Patent Office, chose this method of construction, given that they had administrative freedom to choose a different method. Instead, they chose the least rational rule that they possibly could, and that should give you some sense of what kind of judgment is over across the Potomac at the Patent Office. That would be all.
Thanks, John. Our next speaker is Stuart Graham. There we go. Stuart also has a distinguished resume. He teaches strategic management at the Scheller College of Business at Georgia Tech. He's both a lawyer and an economist. And he was the first chief economist at the USPTO from 2010 to 2013, and I guess continues to work for them in an advisory capacity. Stuart?
So thanks, Tom. Hi, everybody. Thanks for coming today. Let me start off by saying that my full-time job is as an academic at Georgia Tech in Atlanta, and while I do still serve as an advisor to the USPTO, I'm not speaking for them today. My comments are my own. But that also allows me to dovetail a bit into something else I want to say, and that is I think increasingly among those of us who generate evidence in this space, who do research, are economists and other social scientists, that we've begun to have pressure on us, and I think it's appropriate pressure, to disclose our potential conflicts. So I'm going to do that before I start speaking today. I am, as I said, I'm a full-time professor at an academic institution. We pursue patents through our technology transfer office, and I continue to serve as an advisor to the USPTO. I earned a really minimal amount of money, several $1,000s last year doing that. Apart from that, I've received no grants, no funding from organizations that have a real interest in this space, and I just think that's important to say. So let me start off my comments by getting back to the main proposition that that Tom asked us to consider, and that is what evidence is there. And I think our prior two speakers dealt with this issue a bit, and I probably can't do any better than something that was said now over 50 years ago by Fritz Malcolm, right? And that is when he was asked, economist, whether there was sufficient evidence to do away with the patent system. His answer, paraphrasing, was, if we didn't today have a patent system, we probably wouldn't have enough evidence to create one. But by the same token, having one now, there's not sufficient evidence that we ought to get rid of it. And that's how I feel about this question of the existence or the benefits that flow to society from having a patent system generally. So this is the, if you like, it's the Waldron and Levine question that Eli brought up earlier, right? The economics profession has not, certainly there's not a generally accepted position on what role patents play in competition, in creating appropriate incentives, to fueling beneficial R&D, to questions of social welfare, how much better or worse all of us are for the existence of a patent system. And that's partly a failure of our profession, but it's also partly a failure of the availability of data, and also the nature of intellectual property and patents themselves, because they're so wrapped up in a whole cluster of other intangibles and investments in innovation that firms make. It just makes it a really difficult empirical nut to crack. That said, I don't agree with Waldron and Levine that there's absolutely no evidence. There is some evidence. There's evidence on both sides of things. I just think that a fair reading of all the evidence is such that that we really can't come to a definitive conclusion. So, let's spend a little bit of time, though, talking about where a lot of this problem, a lot of the perceived problem comes from. It largely comes from concerns about, let's be honest, electronics, computer and communications technologies, software technologies, more recently business method technologies, oftentimes implemented in the internet. And this is it is from these industries and is perceived issues in these industries, by and large, that is driving much of the concern here. And indeed, much of the money that's flowing in lobbying is coming from those industries as well. Not surprisingly, one is going to follow the other. As an economist, thinking about litigation as an issue, one useful way to think about litigation is as the outcome of a bargaining process. In some sense, as a failure to bargain, failure to reach a deal in a bargain. And indeed, we've seen, at least it's been reported, that we've seen a substantial increase in the amount of litigation, particularly in this space, particularly in the electronics, communications, computer space. And in some sense, it's not terribly surprising. It's not terribly surprising because of one thing that Eli pointed out, that is the growth in the number of patents over time. But it's also not surprising because of the character of these things. What we call in the field, we call these complex technologies. as opposed to discrete technologies. Why complex, or why complex products? Because oftentimes many multiple patents are necessary in order to bring a product like this to market, unlike, let's say, a drug that in many instances may only have one patent riding on the molecule and protecting many hundreds of millions of dollars, if not billions of dollars of revenue. That just doesn't happen in this case. It turns out that from an economic perspective, some very beneficial things are happening in this marketplace. A lot of specialization. Some firms specializing in very discrete areas of technology that ultimately provide that technology to the downstream players that sell this stuff in the marketplace, the Apples, the Samsungs, et cetera, et cetera. So there are a lot of bargains going on. There are a lot of deals being made. And that's beneficial. And that's beneficial because it allows for specialization, and we've known, at least since Adam Smith, that specialization drives efficiency. So we have a lot more bargains going on in these complex technologies because there are a lot of additional products, inventions that are embedded in these things. And as a result, we see, it's reasonable to assume that we will also see more failures of bargaining and more litigation activity. Now that doesn't wipe it all away, and to indeed get back to one of the issues that we heard about earlier, this large increase since, say, 1980 in the number of patents. Economists have looked at this issue, and indeed much of the growth in the number of patents since that period of time has been driven by patenting in the information technology space. Also, though, we have to remember that in 1980, back in the days when we had 70, 80,000 patents, we were just coming out of a couple of decades in which the antitrust authorities and the courts had been essentially at war with the patent system. Rather famously, Xerox was ordered in the late 1970s to actually disgorge its entire patent portfolio and offer what was a compulsory license to all competitors, including the Japanese competitors. And by the early 1980s, people started to realize that maybe, given the competitiveness crisis we were facing vis-a-vis Japan, that maybe wasn't entirely a strong competitive play for the United States. So I've been asked to wrap up, so let me do that. No, it's quite all right. I look forward to talking about these issues because I actually do believe that at the end of the day, while we do have an absence of evidence on many of these issues, there are some clear issues that we can deal with. I do tend to agree with Eli that many of the asymmetries, particularly in the litigation system, are problematical, and they are driving some behavior that appears to be not optimal. And so I look forward to talking about the legislation when I'm sure Tom is going to ask us to do that in a bit. So with that, thanks.
Thank you. And could I get that piece of paper back in case I Thank you. Our next speaker is Mike Moyer, who is the Abraham and Lillian Benton Scholar and Professor of Law at Boston University. He's also both a lawyer and an economist. And before coming to BU, he was an economics professor at Duke and later a law professor at the University of Buffalo. He's, I'm sure, known to most of the people in this room as the author of the famous $29 billion estimate, which I don't know if he's going to get into that or not, but we can. Mike?
Thanks. I'd rather you remember me as the author of Patent Failure. If you haven't bought it, please rush right out, open that phone up and order it. You'll find that extremely helpful, I think, in considering, reflecting on patent reform and whether it's desirable. It is. That's the punchline, but I'll go into a little bit of detail right now. John is quite right that not only evidence matters, but also theory. And the kind of theoretical approach that John might embrace, I think I would share, that if we understand the patent system as a kind of a property system, then you'll understand why reform is needed. So I'll get to that point in a bit, but first I want to talk a bit about evidence. So as Eli told us, economists have trouble finding evidence that the patent system stimulates the sorts of things that we think it should. Let me tell you a little bit more about that. Economists have had great success using econometric techniques, establishing that tangible property rights encourage growth and encourage investment. Using the same techniques, economists have not been able to provide evidence that patent systems or strengthening patent systems encourages investment in R&D or contributes to growth. The evidence does show, as Tom alluded to earlier, that a strong patent system sometimes stimulates an increase in R&D in the pharmaceutical industry and increases imitation costs with regard to the pharmaceutical industry. The lesson I draw from that evidence, I think the best conclusion consistent with the economic history of patent systems is that patents can sometimes succeed as property systems. But property rights on intangibles are difficult to manage. They have to be fine-tuned. They have to be attended to very carefully. And reforms that we're considering, that Eli sketched out, will contribute to a more sensible patent system that makes the patent system more like a tangible property system, likely a more successful system. So, innovators today are burdened by an explosion of patent litigation, started around 1990. In the decade of the 90s, the amount of patent litigation in the US doubled. It's very important to understand that during that decade, there was hardly any litigation by NPEs. So the patent litigation explosion, the basic failing of the patent system, predates activity by NPEs. There is a core problem with opportunistic patent lawsuits that I'll sketch out in more detail in a moment. The right way to get a sense of the rate of increase in patent litigation is to compare it to expenditures on R&D. And from the 90s, over the next 25 years, the rate of increase in patent litigation has far exceeded the rate of increase in spending on R&D. On top of that, not only has the rate of patent litigation increased, but the cost of patent litigation is growing over time in comparison to real dollars, or in comparison to expenditures on R&D. So the burden is growing. You've seen press recently covering a kind of quibble about what's happening in the past couple of years to patent litigation. Is it higher today than it was 6 months ago, a year ago? Maybe. It doesn't really matter very much. If we go back to 2010, 2009, where patent litigation rates were much lower than they are today, we had an extremely serious problem. So what's happened in the last couple of years is not very important. The problem was there in the late 90s, and it's grown worse over the subsequent 15 years. So in what sense do we have a problem? We have a problem because in most industries outside chem, pharma, medical instruments, and devices, the value of the patents that I obtain as an innovator is real, but it is less than the expected cost associated with other people's patents that may be opportunistically asserted against me. Opportunistic in a couple of senses. Most patent defendants, I hope you all know, are never shown to be copyists, never shown to derive the technology that they are using from the patent owner. Most successful patent plaintiffs make no attempt to transfer their technology in advance to the innovators that they're suing. Most innovators have larger patent portfolios than most plaintiffs. Most defendants in patent lawsuits are spending more on R&D than the plaintiffs are. You know, it's not the picture that the press might draw of defendants who are pirates. Very far from the truth. The reason that opportunistic patent lawsuits are so common is because typical patents fail to behave like a property right. The characteristics I'd like to see in a successful property system are, number one, I know that a property right exists. Number two, I know who owns it. Number three, I know the scope of the right. When you provide those conditions in a property system, it is possible for people who care about property rights to avoid them if they choose, or to negotiate permission in advance. Those conditions are satisfied when it comes to pharmaceuticals. That's an industry where you will see rigorous patent clearance. You will see ex-ante licensing. You will see transfer of technology in advance. All of the characteristics that we desire are present in the current successfully functioning pharmaceutical patent system. Those same characteristics are largely absent in the patent system as it applies to most technologies and as it applies to most industries. So why are people talking about patent trolls? I told you that we had a problem in the 90s before there was any troll litigation or significant amounts of troll litigation. Eli talked a little bit about this. We have a couple of issues. One that Eli talked about quite a bit is that many of the patents that can be opportunistically asserted moved from operating companies who might have asserted them in the past into the hands of NPEs. Not all of them. So there are still operating companies that troll, the verb that Eli was using, and there are NPEs that troll. Secondly, we have a new kind of patent litigation. We have wide-scale, frivolous litigation by the parties that are characterized as bottom feeders. These are the parties that are criticized by people like Peter Detkin. You know, many people, including patent monetizers, recognize that there is extensive bad behavior. So those two things have compounded the problem associated with modern patent litigation in the last decade. More bargaining power in the hands of the party asserting an opportunistic patent claim, and a dramatic growth in the amount of frivolous litigation. So I applaud reforms that are addressed to the problem of frivolous patent litigation, but I hope that we do not lose track of the more basic problem. We need to reform the patent system incrementally over time through all possible actors. There's a role for Congress, there's a role for the courts, there's a role for the agency to move our patent system back to a more property-like system. So, I don't see anyone telling me no, don't go on.
Well,
So,
that's because you sound like you're wrapping up.
all right. Before I wrap up, I will make one last comment. You've heard probably from many sources that there's something to fear about reform. There's something to fear about unintended consequences, right? You know, it's tautological, isn't it? If we act, if we reform, there may be unintended consequences. I've heard those arguments back in 1995 with the AIPA. There was extensive criticism of those very modest reforms on the grounds that they would destroy incentives for small inventors. Didn't happen at all. In fact, we had a flourishing after the reforms of 95 of innovative activity by small inventors. We saw in amicus briefs that eBay and KSR would seriously weaken the patent system. Hasn't happened. It's coming, it's coming, it's coming.
You know what it is.
All right, so 2 sentences. Despite KSR, number of patents applied for every year continued to skyrocket. Patent grants skyrocketed despite eBay. People continue to invest very heavily in our very successful, very innovative economy. The fears are repeated every time there's a significant attempt to reform in the courts or in Congress, and they are repeatedly proven wrong. And they're understandable. These are criticisms made by people, partly in pharma, partly the APLA, who are quite happy with the status quo. And I want you to sit and reflect a bit about what are the real risks. I think they're quite modest, and I think we could address them if they emerge.
Thank you, Michael. And last but certainly not least, we have Michael Risch, who is a professor of law at Villanova. Previously, he directed the Entrepreneurship, Innovation, and Law program at the West Virginia University College of Law. He has been an Olin Fellow in Law at Stanford Law School. He was a partner at an intellectual property boutique. So he has a lot of experience actually practicing patent law. So it's a pleasure to have Michael here.
Thank you, and thanks for having me here, and thank you for coming today. Since I'm batting cleanup here, I will try to keep my points more general, and we'll see how I do. I've got 5 points I'd like to make. I guess it's about a minute and a half each. We'll see if I can do it. The first thing I want to say, which it seems like everybody is agreeing on, is that it's not really about who, it's about what people do. So, for example, it's about sharp practices in litigation. It's about demand letters being sent widely. It's about bullying. One thing that hasn't been discussed is about big companies versus small companies. One thing that's often missed in the patent reform is that big companies are happy to use patents to keep smaller entrants out. They're just not so happy when they get sued on those patents. The interesting thing about all of these, including, for example, making patents more clear, as we just heard, which a goal that I agree with, none of those are in this bill. None of those things are in this bill. It doesn't handle demand letters. It doesn't handle sharp practices. It doesn't handle bullying. It doesn't handle worries about entrance by small companies. Point 2, you always have to look through to the underlying innovation. And what I mean by that is, number 1, the studies about does the patent system increase R&D? Does it increase growth? My own view is that one of the benefits of the patent system is it drives investment in the activities that wind up leading to patents, venture capital, and the like. So for every patent troll you hear about, my own view is you have to look through and see, where did the patent come from? Did it come from somebody who got a patent and sat on it and did nothing? Sometimes. Was it somebody who tried to license it early and was rebuffed because regardless of the patent being clear, big companies were just not willing to listen unless they were sued? Perhaps. Was it a small company trying to appropriate a niche of business? For example, anybody who watches Shark Tank knows that patents have some value. Even Mark Cuban, who funded a position at the EFF to get rid of stupid patents, asked the question, do you have a patent on that if it's something that's easily copied? Not everything, only some things. Point number 3, and this ties to point numbers 1 and 2. When we're looking at the evidence, you have to consider the but-for world. So for example, when you're looking at the costs of litigation or the amounts of litigation, you have to have a control group. If patent trolls are costing so much, what does non-patent troll patent litigation look like? And if there's a difference, does it make a difference? Similarly, the patent explosion we just heard about. It turns out that if you look throughout history, there's always a patent explosion whenever you have a new important industry. There was a patent explosion when the telegraph came about. There was a patent explosion when the automobile took off. And now there's a patent explosion when computers and now wireless communications take off. So the question is it because there are bad patents? Maybe some. Or is it because when you have new technology, you have patent explosions? You have to have something to compare it to. Number 4, and here's something I think we all seem to agree on, litigation is expensive and it needs to be cheaper. So for example, when a demand letter goes out and says, pay us $2,500 because it's going to be cheaper to settle, that's a problem. The problem is, of course, that this Patent Reform Act doesn't solve that at the demand letter stage. There are also things in this proposed act that don't make litigation cheaper. So for example, claim charts put in the complaint are not cheaper. They're more expensive for everybody. Additionally, what might be cheaper is phased resolution and discovery. So for example, having some discovery put off. Some of the discovery that's very costly is damages discovery, information about sales, etc. That might be cheaper, but not limiting it so much that you can't get basic discovery, for example, about how products work. The current reform, as I read it, would limit any kind of discovery, even on potentially infringing products, before there's claim construction. But it's pretty well versed in the law that it's helpful for the court to know what is at issue, what the infringing devices might be, so that the parties can figure out what to fight about. Otherwise, you're fighting about every single word because the patentee doesn't know what the issues are. This leads to my final point, which is number 5. It ties again to the historical point, which is that we should be very careful about discarding things that are distinctly American without some really, really strong evidence. So I'll give you 4 examples from the patent reform proposal. Number 1 is fee shifting. We are not a fee shifting nation. This adds fee shifting. Number 2, piercing the corporate veil. This not only adds fee shifting, but pierces the veil and only does it one way. It doesn't pierce the veil for the defendant who infringes, and we go after all their shareholders and all their parent corporations. It only pierces it for the patent holder, and this is distinctly American. And it's weird, I'll tell you, it's weird. When I was a first-year law student, actually a second year, I guess, and I took business organizations, and we read the yellow cab case about the yellow cab who ran this poor woman over, and basically the cab was a separate corporation that went bankrupt. It was a cruel indoctrination into how limited liability works. But that's how it works in this country. We shouldn't discard that without some real thought. Number 3, small inventors. We should think hard about how small inventors are going to be impacted about this, and I don't think anybody has thought about that. I know people say, well, small companies are being hurt by patents, although it's weird that there's a real split in the venture capital community about this patent reform bill. The Venture Capital Association says no, but then some venture capitalists say yes, primarily because they are in software and other high tech. But I hear very little talk about what happens to small inventors. Now, it may just be that we don't think small inventors are doing a lot of good for society, and we don't care what happens to them. If that's true, that's okay, but we should think about these things. All of these tie together to access to justice. If you sure all of these things in the proposal are neutral and they're measured and they're not targeted at patent trolls, but they're all designed to limit access to justice. And the question is, do we want a system where we limit access to justice? Yes, there may be too many lawsuits. Yes, litigation is expensive. The question is there a way that we can do it without limiting access to justice? Thank you.
Thanks, Michael. Well, those are all really, really great presentations. Wait, does anybody have anything they want to say before I start with a couple of questions of my own? Okay.
I'm Mike. So I wanted to observe something about what John told us, that we need dozens of patents now to build up and solidify your rights. The word need here, I think, is maybe being chosen from the perspective of a patent prosecutor. You know, you need to bill more hours, you need to have more patents that you can file. You know, back to my favorite industry here, pharma. There's research, Mike Shearer or Ernie Berndt, I think one of those guys, that says that for a new molecular entity, there are 2.5 patents. So that when the patent system is working well like it is in pharma, where the most valuable patents are, the number of patents that you need to protect your most important advances is small.
Can I just respond to that?
Can we follow up with a question? So would you,
I get some responses.
You do.
Okay.
So would you suggest, you know, that a lot of these things outside of the pharma and chemical area, like software, et cetera, should not be patentable? Is that where?
I may suggest that, but that's not my first choice. My first choice is that we, as Dave Kapos has suggested, significantly push for a stronger 112 enablement requirement. We need to continue to follow through with a strong written description requirement. We need to continue to apply a significant subject matter test that excludes abstract ideas from the realm of patentability. We need to push to make sure that Nautilus is applied effectively so that we can get rid of the many claims that are indefinite, ambiguous, vague in software patents. So there are many, many opportunities in the existing system to push for property rights over software inventions that really look like property rights.
No, okay, so I wasn't going to, do I have to push this button? No, that's not, okay. One thing that Mike said, I just want to sort of call out before I move on to his comments on mine, is he said one thing that is true in patent litigation, and it is true, that most infringers are never shown to be copyists. But you've got to read it, you've got to listen very, very carefully whenever a lawyer talks. You've got to have another lawyer help you interpret that. Because there's almost no incentive in the patent system to show somebody is a copyist. The infringement liability doesn't require that. So most people simply don't litigate that. It's another whole fight about discovery and about interviewing witnesses where there's simply no bang for the buck. So it is true, the most defendants are not shown to be copyists, but that does not mean that they're not copyists or that they didn't get the information through the teachings of the patent, which are put up on the internet these days and can be widely viewed. I mean, most people think that information flows relatively freely and costlessly in our society. I think there's some critiques of that, but nonetheless, you just have to be careful with that. In terms of need more patents, I certainly did not say it from the standpoint of a money-grubbing patent prosecutor who just wants to bill more hours in patent prosecution. I think in my lifetime, was involved in the prosecution of 1 or maybe 2 patents for part of the time. So I have not spent a lot of my life doing patent prosecution. What I mean by that is that the courts themselves, under the Federal Circuit, which was one of the last major reforms that the Congress gave to the country, and actually some of Mike's complaints are about the Federal Circuit. So the point about unintended consequences is a real one. You can create something like the Federal Circuit and it can have some real unintended consequences. But that they interpret patents in such unpredictable ways, documented unpredictable ways, that if you're a patentee and you're trying to protect your real substance of your invention, you need 50 or 100, maybe even 200 claims to have different permutations of your technology because you're never too sure exactly how they're going to define their claims. And the last thing I'll say is that the bureaucracy a lot of the legislation has moved this over to a bureaucracy that I think everybody here must agree has failed. I agree that there are a lot of invalid patents out there. That has to be a failure of examination. So the question is, if you have a large unionized bureaucracy which has failed, what do? You pass legislation that expands its power and throws more issues over to that bureaucracy? That does not seem like the kind of legislation that should be on the top of a Republican House of Representatives agenda.
Okay, I just got to jump in here really quickly.
Go ahead.
A couple of issues, right? I'll take each of these guys on. One is concerning the limited number of patents associated with successful pharmaceutical patents. Absolutely right, there can be as few as one that protect essentially the molecule. But when you actually look at the patenting by successful pharmaceutical companies, look it up on any website, Google, whatever. Look up Eli Lilly and look at how many patents they're actually holding. Organizationally, they are holding thousands and thousands and thousands of patents because, of course, a pharmaceutical company and successful commercialization as a firm requires innovation across a wide range of activities. It's also not entirely fair, and I know this is a point, and I think it goes to one of Mike's strongest points about what it means to patent in an area that has a well-developed scientific and historical set of terms associated with it, like chemistry, compared to many of the newer technologies, internet, software, computer and communications, which is much less, which is a much less well-developed, much less standardized set of terms. But remember also that when we see a pharmaceutical product, it is also probably 8 to 10 years old already. And if you look at the history of its patenting over time, there's been a lot of stuff going on, okay? That's not true of these much younger technologies that we see in electronics. On the issue of the bureaucracy, let me just say that the fact that there are, and I agree, there are a lot of invalid patents out there is not necessarily a result of a failed bureaucracy. I would tend to say that it is actually a consequence of what it means to be an innovator and what innovation is. Remember that when, particularly under the new law, a patentee is rewarded for getting into the patent office early. And that the timing is important here because we reward inventors for getting into the patent office early at a time when uncertainty is the highest, not only about the technology and what's going to happen in the development process, but also in the commercial prospects, in the legal treatment, so there's a lot of uncertainty associated with this. And some of that uncertainty is certainly resolved by the time that patents issue, but not all the uncertainty can be. Nor do we as a society necessarily do better by investing a lot in ensuring that each and every patent that is granted by the office is a 100% high quality patent. Because of course we know that many of them are not going to pan out. Optimally, we should invest enough to ensure that we are separating the really bad part of the distribution out, and then, as we've done, put in staged decision making through post-grant review, through courts, and other mechanisms to allow for uncertainty to be, and that uncertainty as it resolves, to help us steer through and comb out more of the chaff. Right? So staged decision making, because we are always going to face uncertainty that can only resolve over time.
Okay, let me see if I can get a few points of agreement, and then so I'll use what Mike said as a jumping off point. That and essentially what I heard him say is that we need a intellectual property system that is more akin to our real property system, our real estate property system. We know that something exists, we know who owns it, we know what the boundaries are, and that would be a better system. And that the, at least in important areas, the patent system now does not live up to that. We'll need to see if we do have agreement on that.
Yeah.
No, we don't have agreement on that. So here's what I think. I think that defining property rights in some things is easier than in other things. And it takes a very large and sophisticated society to have property rights in ideas and intellectual property. I have history on my side in the sense that if you want to talk about property rights in things and real estate, you could go back at least 2,000 or more years. The Romans had a system of property rights. They understood that sort of system. We did not even begin to develop a property rights system in ideas until the earliest time is the 15th century that anybody can possibly take it back to. And really no functioning system existed until probably the 18th century of any economic consequence, and that only happened in some countries. You need an extremely large and sophisticated society that can devote some very smart people, namely patent lawyers, who are at least arguably smart, to deciding all these property rights issues that do come up in an intellectual property system. So if the standard is that we need to have our science so advanced that we really have this great system before we institute an intellectual property system, then we won't have an intellectual property system when it matters most, which is when a field is vibrant. As I said, in 1840s, if you go back and read medical patents in the 1840s, they were horrible. A lot of them were snake oil. They didn't have a system, a very good system for describing them. It was true that a lot of them were bad. So the AMA had something, they were not just blowing smoke. There was something there to be said for saying that a lot of the patents that existed in that day and age were terrible patents. Because it was an embryonic system of medicine, an embryonic system of science, and an embryonic system of property rights. Our society struggled through that to get to the point where we are today, where people live decades longer than they lived in 1840 because of modern medicines. So I think you have to realize that if you hold out the standard that we want to have everything as clear as my property rights in this phone, then you're never going to get there with the intellectual property system or the patent system for the foreseeable future.
I want to push back a little bit, John. If you look at medical patents in the 1840s, they weren't molecules that were being patented. No. They were recipes. Which are actually not patentable today. So actually, the law that we have today, which is molecules, or
certain food recipes are not patentable, but certainly
these patent medicines of
are they patentable? Yes.
Food recipes from 18th century or 19th century medicines is where we got cocktail bitters. They were food.
And food recipes today are patentable. I've got several examples of major corporations like Procter & Gamble patenting new kinds of oils that are low fat and other things like that. I've got them on my computer. I can show them on my hard drive. What you can't patent is kind of a new combination of existing spices and whatnot, because that's viewed as obvious in the sense that if you take the set of edible things, you can combine them in an infinite number of ways. And it's obvious that you can combine them. Whether they'll taste good or not is unclear. But all of them are viewed as either non-novel or as obvious.
So, but those medicines would probably have withstood scrutiny under.
They would have withstood scrutiny today. So recipes are perfectly patentable if they have some utility associated with them, rather than just being aesthetically pleasing. So, for example, there are companies like Procter & Gamble that are patenting new kinds of food oils and sweeteners and other kinds of things.
But not like there's no patent for Coke. It's a trade secret.
Well, I don't know whether there could be a patent for code, but they chose not to do that, and because they thought trade secret is a longer term protection. And that's one wonderful thing about patents. They do expire in a relatively short period of time. The technology that the Wright brothers invented, many people don't know this, they actually didn't patent the plane. They patented an aircraft stabilization system, which is very sophisticated and is still the basis for stabilizing a large fixed-wing aircraft. And they actually patented. If you go and read their claims, there was some language in there that is very hard to interpret, and a few key decisions interpreting their language in an unfavorable way would have left them with an economic right of zero value.
Okay, I have more questions, but I'm going to see if the audience has questions and then let them in on it. And we actually need to have microphones. Somebody, here we go. And if you could identify yourself and your affiliation.
Hi, I'm Matt Levy with the Computer and Communications Industry Association. So, I guess first, pharmaceutical patents or medicine patents in the 19th century were terrible because those medicines were terrible and dangerous and not particularly effective. Revolutions in pharmaceuticals didn't happen until the 20th century, really.
That's right.
So I don't know that we can draw examples. I guess I worry about historical lessons to a point, because some of the argument that I think Professor Duffy is making is we made arguably mistakes 150 years ago, therefore we shouldn't, we should be careful of making mistakes now. We should always be careful about making mistakes, right? I mean, I guess I don't know that gets us anywhere. But the real dispute about whether we have a problem in, how do I want to put this? Mike Moyer is talking about property rights, which is a really fascinating idea that these things should be clear. The fact, I guess, you talk about the Wright brothers, and I hate to harp on this, but their patents, the warp wing thing is actually not the way that we stabilize aircraft now. It's using ailerons, which is not, they argued, of course, that they were the same thing, but we can take that offline.
And a court so held. Every court to consider the issue so held.
Non-technical judges.
Including learned hand.
Fair enough.
Who knew a lot about aircraft?
Right.
And knew a lot about it. Well, actually went through the record in quite a lot of detail. But that's just the facts. Don't let that stop you. Go ahead.
No,
Go ahead.
hey, the Wright brothers
So we should
also.
believe all judges? Did you see the Alice case?
And actually, the airplane industry stagnated until the U.S. Appropriated
that is
patents.
false. That is false.
Anyway, well, let me
It's
open up another
lively,
can.
right?
Tell you what, we'll talk about that later, because we should really focus on the evidence part.
Question, Matt? Or?
I've almost forgot. I think I may have forgotten my question.
I'm sorry.
No, but the real point here, I think, is focusing on I guess I would like to have the panelists focus on the evidence, the question of whether there actually is evidence one way or another that there's something to solve. I mean, one thing that we've heard, and maybe people can address this, and like Professor Duffy said in this letter, that's saying that there would be really horrible consequences to passing the Innovation Act, and I guess I'd like to understand what the evidence is one way or another for what the consequences, possible consequences would be of passing the Innovation Act or something similar.
Of passing the, well, first I want to step back and talk about the evidence generally. Because we have been talking a lot about the evidence, and the one thing that is missing here is, I think, evidence of a country that has abolished its patent system and then actually exceeded the U.S.'s production of innovation. We've had a patent system for 200 years, over 200 years, and we've always thought of our nation, and I think there's some history to bear this out. We thought of our nation as a relatively innovative nation, even before we were a world power back in the 19th century. And even when we were thought to be rather sort of an upstart country. So what we're lacking is that other country who can say, you know what, we should really imitate that other country, because that other country has abolished its patent system. They've just gone to a Hayekian notion of we'll just have pure price competition and that will lead to innovation. And boy, they are just knocking our socks off in terms of innovation. Instead, we have this patent crisis that everybody's complaining about, and yet still, we seem to be one of the most innovative economies in the world. So that's what I'm looking for. I'm looking for that other country that is outstripping us without a patent system. Remembering that prior to, you know, the 18th century, there were a lot of countries without patent systems, and they weren't as innovative.
Well, Petra Moser found, actually, that looking at some world fairs, that countries with weaker patent systems had more likely to win prizes at the world's fairs, and so on.
They were equally.
Let me ask, just keying off what John just said about other countries. Other countries, apparently, I'm sure you know better than I, we're one of the few countries that does not have a loser pays or some variant of a loser pays system. So, and that's actually, I think that's probably one of the more, probably would be considered one of the more radical parts of the Goodlatte bill. So let's discuss that, what people think would be the consequences of that, and what the consequences of it in the rest of the world.
I think that the loser pays system, just applying the game theory, right? The logic of game theory would be expected to reduce frivolous cases, and that's something that's generally true, not just applied to the patent system. And I think we do see less frivolous cases in loser pays jurisdictions like the UK. So I would be an advocate of adopting a loser pays rule for all litigation, all civil litigation generally.
So one thing, I actually studied this as an academic a while back. I probably should write up my findings. I was when I was just starting out, and I got sidetracked on other things. I actually wondered, how did we wind up as a pay your own way system? Because after all, we're descended from the English, right? Our legal system is often called the Anglo-American legal system. So how did this happen? That that the English still have the loser pay system and we don't. And I found out that at the time of the founding, actually, we, not surprisingly, did have the English system. And what happened there was that it was the colonists and early United States lawyers' rebellion against price regulation that led to the American rule. In other words, if you're going to fee shift, as soon as you say you're going to fee shift, there's going to be some inquiry into the amount and size of the fees. So what happened is that early lawyers who were very good at their job began to have side deals with their clients, like Adams. And he would say, well, you know, I get the fee shifting under the English rule, but if you really want to retain me, you have to pay me something else. And that became, over time, over a several decade period, became the principal source of lawyers' income. And it's still true that if you want to see the English rule, we still have it in a vestigial form, which is costs. If you look at nowadays, people don't even remember that, you know, the loser pay is costs, and they're called court costs. If you go back in time, you'll see in the early 19th century that used to include a teeny component of fees, a few dollars, which of course at the time was real money. And it's some jurisdictions have abolished it, but if you want to know why we moved off loser pays, it's because of our system of free enterprise, of not regulating the legal profession. Now, I'm not, beyond that point, I just want people to understand that that point is historically true. I don't know about the game theory. I've often thought maybe losers pays generally might be a better system. I've thought about that, but know that there is something deep within our tradition that accounts for why we moved off the English system.
Yeah, and also, I mean, considering what Eli said, I mean, obviously it would discourage frivolous suits. I think the concern of some people is that it would discourage legitimate.
Well, this without question. So, in terms of what we might get, it's important to understand that we do, in egregious circumstances, have an opportunity now for judges to do some fee shifting. So it's not as if this would be a introduction of something that's not there. It would be an expansion of something that's there. Number one.
Default, right?
Yes, indeed. But look, that, you know, from a theoretical perspective, and I tend to be probably more in favor of some expansion of fee shifting, only because from a theoretical perspective, it's those cases fee shifting tends to get rid of the most egregious cases, and those are the ones in which, remember, as a rational litigant, right, a rational patentee, you're going into a case with an expectation that you're going to get more out of it than what you spend, and the getting more out of it is formulaically, it is a probability times a potential gain. And so if you have a very small probability of winning, but the potential gain is enormous, that can still drive you into litigation. And those are the cases that we probably want to try to comb out if we can, because if litigants have a, expected success rate that's de minimis, that suggests to us that they don't even believe in their own case, right? And those are the ones we want to get rid of. However, as Tom says, as we get closer and closer to the line, right, the 50% line, we're still going to be discouraging some litigants from going forward. And so those who bring that up as a potential cost are right. What we do about that is another question.
Let me see if there's I'd like to give the audience a little more opportunity. I think the lady back there.
Yeah, my question is for...
Could you identify yourself, please?
Yeah, I'm Lauren with Congresswoman Susan Delbene.
Okay.
Mr. Duffy, I thought your comment about expanding bureaucracy and that being a problem in terms of patent quality was very interesting, but I'm curious if you're aware that, the fees that the PTO is collecting has been subject to the annual appropriations process. So I'm not sure how that really squares with your argument, and I would just pose to you that, the more complicated our technologies become, the more difficult and the more work is going to be involved for the PTO to go through them and make sure that we're really issuing good quality patents. How does a smaller bureaucracy that's been frankly starved for resources, there was actually one figure that said since the 90s they've lost like $1 billion in fees at the PTO. So how does that square?
So one thing to ask is, how does a really small country run a patent system? So for example, I have an article on this. How does Israel run its patent system? Israel can't afford 5,000 engineers to go be patent examiners. How do they do it? And the answer is that they engage in a massive parallel work sharing with the rest of the world. They will issue a patent if it comes from any one of, if you get a patent in any one of 13 pre-approved patent offices and you show up on their doorstep, they'll, by law, issue a patent to you. Perhaps there can be slight differences in their law that somebody can later challenge and suggest that there's a difference between their law and maybe US law or EU law or Australian law. But that allows them to run a very, very efficient patent system. Now, the bureaucracy and the union that is in the USPTO is absolutely dead set opposed to any type of international work sharing. They want to keep the size of the bureaucracy as large as it is and to grow it more. And that is not sustainable. It's not sustainable for Israel right now to have its own patent bureaucracy. It's not sustainable for us. More patent applications are currently filed by people outside of the United States than inside of the United States. That's not because we're an uninnovative country. It's just because we're about 11% of the world's population, and we're producing about half of the applications that go into our patent office. We need to engage in more work sharing. We need to think about ways to engage in privatization of the patent office functions, which we could say that then we could hold people accountable. We could say, this firm has been issuing several bad patents, and that would actually be a scandal rather than sort of business as usual at the patent office. We could do that. We can see traces of that in the country. I know you're looking in a puzzled way, and it's because we need imagination to do that. But I'm telling you that there are ways to see it happening in the rest of the world, and there's ways to move forward in this to obtain better examination in a less expensive way.
It doesn't have to be a zero-sum game. Okay, I do agree with John to the extent that we need to work smarter. Work sharing is one way in which this could work very well.
And is the union in favor of that?
I don't know what the union's position is.
Okay, we could
Or, well, I'm not going to comment on what the union's position is. Work sharing is one way we could go, but the other way is to really deploy at the Patent Office 21st century information search technologies. This is something that the Patent Office is trying to do, but we could all do a better job. The other piece, though, that I will say here is that personnel can also be deployed to do other things. So, for instance, if a concern is, and this is a concern about many in the patent demanding community, those that put in the applications, that oftentimes they don't get enough time with the examiners. Well, frankly, this is one way. You know, if you work smarter, then you're able to deploy more time to each application, right? If it's optimal. Right? Again, going back to my early comments, it's not necessarily optimal to spend more on each one coming in the door. The other thing that, of course, that we should care about is the process and the staged process of review. There, over time, seemingly there are going to be opportunities to redeploy people into activities associated with a more robust process of review. So again, I just want to say this isn't necessarily a zero-sum game for the PTO.
Thank you. Hi, I'm Paula Stern. I used to chair the U.S. International Trade Commission and remain very, very concerned about assuring American leadership in innovation and competitiveness. Hence my question. There was a reference to the IBM decision and the implications on Japanese competitors being able to pick up off of that court decision with regard to, if you will, sharing or giving the patents. There was another question tossed out here about the kind of what if, who is our competitor? Well, I think a lot about China with its advantages both with regard to the number of engineers and capability, just sheer numbers, as well as the fact that they are going to be the largest consumer. And it's, in my view, at least from a competitiveness point of view, the piper pays the tune. And if the consumer, the major consumer, will have a major impact on what the rules will be, no matter what. And so I think U.S. is now facing a very interesting future. And the question in my mind is, what about our patent system that China doesn't have that will advantage us and keep our advantages? I'd like you to just address that more straightforwardly. I know there's no evidence here, but I do think that we are talking about ideas and that our system is based on this idea that a patent system does make a huge difference. Finally, if you want to just say, does the ITC play a role in thinking about these trade issues, these competitiveness issues? What future should it play in legislation?
So, since we're actually kind of running out of time, if everybody would like to simultaneously address Paul's question, but also give any final comments. That what?
Might have started the other end.
And we'll start at the other end. Simultaneously give any closing thoughts that they might have.
Well, I guess the answer to the question is also my sum up, which is, China has a system, but from everything I know about it, it's easier to enforce a patent right here in the U.S. So the question is, how will that change if you reform? Now, the reality is, I'm not that much of a doomsayer. Even with reform, it's probably still going to be more, but the ability to enforce patents will have trickle-down effects all the way down to licensing. Similarly with property rights, I think being able to clearly delineate the patent boundaries is a good thing. I'm skeptical that it will make a difference in ex-ante licensing in the present world.
It's hard for me to fathom China sprinting past us in terms of research and development, because it seems extremely likely that the Chinese society is set up in a way to open the door to rent-seeking activities that have currently been destructive in the US. I think they will be much more destructive in China. I think Chinese are likely to develop a patent system that captures many of the worst features of ours and makes the problems that we face much more severe. Further, what really makes us so successful as innovators is a generous and forgiving bankruptcy law, a very sophisticated and advanced financial system that creates a community like the one we see in Silicon Valley. Many competitors with more tools available than China have tried to replicate Silicon Valley but failed. There are many, many facets of the legal and economic infrastructure in the US that will continue to push us forward to be most innovative. And it's very important to understand that there are some technologies and sectors where patents are helping and many other sectors where patents are hurting. And so the right attitude with the patent system is stop it from doing damage in some sectors and continue to foster it in sectors where it's working well. A sum up on a different issue. John, I'd like to sit here and debate John all day on these issues, and
I'd enjoy that too.
we would have a good time. So I didn't mean to suggest anything about you as a patent prosecutor. I misspoke or I mischaracterized that, but like you, John, I teach patent prosecutors and I teach them to be zealous advocates. So I don't say go out and grub for money, I say go zealously advocate, and that leads them to proliferate patents and patent claims. They're doing what they're supposed to do, and now we need to come in and fix that system so they can't do what they're supposed to do quite as effectively as they have been. In terms of copying, John is quite right. You should be careful when you listen to me or to John. We are both lawyers, and we might say things in a very specific way. John's quite right. And John failed to add, and I wouldn't expect him to, the observation that if you can show copying, you get enhanced damages and fee shifting. So there are tremendous financial benefits from showing copying if you can. But John's quite right when he says you don't need to show it.
So on both these points, and some sum up, quickly. So I don't think it's entirely fair of Mike to suggest. I've heard this suggested in Europe a lot from my colleagues there. Right? How can the U.S. possibly be as innovative and entrepreneurial as it is, given its patent system? It must be all that other stuff they have, because clearly the patent system is otherwise destroying the innovative behavior. The evidence just isn't there to support that, and it's certainly not there to support that in the sector of the economy that drives most of the growth and job creation in the economy, and that's among the entrepreneurial small firms in the country. Evidence not in. In terms of China, I'm concerned about the competitiveness of our firms. I'm not so concerned about the Chinese adopting a system that will be fundamentally anti-intellectual property or anti-ideas. Look, China is coming on, and fundamentally there is a point at which all countries shift from being a net importer, one might say net infringer of intellectual property, to being a net exporter. And indeed, curious little fact about the U.S. If you look back at the copyright law in the United States, one of the reasons Charles Dickens was over here reading his novels was not only to read his novels and appropriate some of the rents that were being stolen from him, because his books could be legally copied and sold in the United States, but also to advocate for a change in that law. So the United States became a net exporter, and I believe China will too. And we do better when we make sure that we have an appropriately organized innovation ecosystem, a innovation system in this country that will provide the appropriate incentives to invest in and keep us innovative into the future. That's how we win, ultimately. And that's why these questions that we're discussing today are so fundamentally important.
I think, with respect to China, I think that we should think two things. One, we should welcome China into the world of developed nations that want to have some degree of economic freedom for their citizens. So if you have to choose between the China of today versus the China of 1970, there's no doubt that you would choose the China of today. It is trying to produce, it is producing things. I'm sure some components of this phone right here were produced in China. Definitely, and that benefits us and it benefits the rest of the world. In order to have a large, sophisticated economy, you need specialization, which Stu Graham just mentioned in his comments. And to have specialization, you've got to have a very large integrated society across the globe. So you can devote whole regions of our nation, Silicon Valley, to develop to one very small thing, to one relatively small product. At least physically small. Other parts of our nation are devoted to other things. The more that we have specialization across the world, the more that we can enjoy even greater benefits as consumers. So I think that is overall it's happy news. Now, in terms of making sure that we protect our intellectual property, we protect what we've developed, I think the way to do that is to foster a culture that is willing to pay for the last generation of technology. One of the things that Mike mentioned, which I think is undoubtedly true, is that if you have a large R&D budget, you probably are more likely to be a target of patent infringement litigation. Because people who are engaged in research and development, and all legal and economic commentators agree on this, is that what they do is they build on the last generations of technology. And if that generation was patented, as it often is, they're going to be drawing from that prior storehouse of knowledge as they invest new resources to come up with the next generation of technology. Now, what we have to do is we have to foster a culture that says the people who did that last generation of technology, they get paid as well. They get what's due to them. They get to recover some of their research and development costs. Even from the next generation of innovators are willing to pay for the inputs. The inputs to the next generation of technology, the inputs to the next generation of iPhone, not only include new money, and new thought. It also includes the last generation of technology. And somebody needs to pay for that. We have to be willing to pay for that, and we have to be willing to make China pay.
So actually, I think that the international situation and international competition is actually evidence that patents and ideas generally are not that important for innovation. What really matters is execution at the firm level. As we've said, several of us on this stage have iPhones. None of us has the cheap Chinese knockoff that infringes on iPhones. Because why? Because it's very difficult to actually execute on the ideas.
Or it's being kept up by the ITC.
We could. You're right. Okay, so you could smuggle it in. There's no demand for it, even in China, right? There's not much demand for the knockoff iPhones. Like, people want the real iPhones, and so I think that really it's actually much more difficult to innovate than it is just to come up with an idea. 90+% is actually execution. So I'm not very fearful of China for that reason.
Well, I first want to thank the audience, those of you who stuck it out. I'm sorry we went over our allotted time, and I very much want to thank the panel for a very, very stimulating discussion.